All rise. Veuillez vous lever. Please be seated. Veuillez vous asseoir.
Good afternoon to everyone. We will continue now with the submissions of the defense.
Madame la Présidente, an affected group would be, to our mind, the most effective and appropriate. And we are even more convinced after we heard the submissions this morning that this is an efficient way of repairing the harm suffered, persecution in view of the large number of individuals. And I will now broach 3 points in support of this. The fact that this approach does not require an individual assessment of eligibility, as was the case in the Al-Mahdi case for the collective reparations, has the advantage of avoiding long delays and extensive costs during the implementation phase. It is important that the money that is to be given during the reparations phase goes directly to the victims, and that this money not be lost in a laborious process. Secondly, this approach makes it possible to address a larger segment of the population and avoid the risk of creating resentment and frustration, and thereby promote cohesion and reconciliation. Thirdly, this approach could be based on the adoption of several presumptions of fact, thereby contributing to a more holistic and transformative approach. And it will enable an opportunity to remedy the harm caused by sexual and gender-based violence without exceeding the limits of the judgment against Mr. Al-Hassan and without holding him responsible. So, if we observe past experience where reparations were given on an individual basis but in a collective context, we can refer to the Taganda case, where collective reparations had an individual component, giving rise to individual rights to reparations within the community itself. However, in March 2024, the Chamber alerted to the length of the process, to the extent that the fund had still not been able to conduct the identification process, and this was 3 years after the verdict against Mr. Ntaganda. In March 2025, the Chamber confirmed that the number of victims considered eligible to date is 1,549, and I'm referring to number 1 in our table. The identification process is still ongoing. We need to imagine what this would signify if we were to apply such an approach, which was adopted in the Taganda case, where the figures were far lower than those given in the parties this morning. Now, adopting such an approach, according to which the participation in collective reparations is based on the belonging to the community itself and not on the status of individual, which does not require the individual assessment of eligibility, will enable the court to reduce its costs and the delays. Now, the Chamber in the Taganda case noted that collective reparations made it possible to maximize the efficiency of available resources, which are already limited and even more so today. I'm referring here to reference number 3. This approach will also enable us to reduce the risks of fraud and identity theft, because the fund, yet again in the Taganda case, noted that some people were usurping the identity of beneficiaries in order to participate in a reparation program. The fund also had to put in place a reinforced procedure for assessing claims for reparations and for remedying this issue. So a collective approach based on collective rights and collective harm would also help prevent this type of fraud and avoid the need for additional steps or mechanisms that cause unnecessary delays and extra costs. So in such a way, we would be able to focus the money on reparations for communities and for the harm suffered by the beneficiaries, as opposed to investing the money in the process itself. Now, lastly, this is a subject that some of my colleagues mentioned this morning. We would invite the Chamber to take into account the obstacles associated with insecurity. In the Taganda case, many of the beneficiaries remain unlocated, particularly due to the insecurity reigning in the region and the many people who have been displaced because of the various conflicts. This is reference number 4. The fund encountered difficulties in contacting certain beneficiaries in order to have them complete a questionnaire and then to have them to proceed or take part in the eligibility assessment. In some cases, this was even impossible. In addition, the Chamber noted in the Al Mahdi case that the issue of security was an obstacle, both with regard to the submission of applications for reparations and also with regard to the provision of supporting documentation. That's reference number 5. These difficulties still exist today in Mali. VPRS and the registry and the fund also highlighted these very obstacles in their observations in the present case, reference 6. The fact that people have to complete and submit claims for reparations for a large part of the population of Timbuktu will be potentially a laborious and virtually impossible task under the circumstances prevailing in northern Mali as we speak. Now, secondly, this approach will promote living together and reconciliation in Timbuktu, focusing on the harm suffered by the community rather than the harm suffered individually will allow a greater number of community members to have access to reparations and thus avoid creating tensions within the community. And as my colleague underscored, this will enable individuals in Timbuktu and outside of Timbuktu and the various groups, the vulnerable groups, to have access to reparations. In the Al Mahdi case, the Chamber also recalled that, and I quote quote, "To the extent possible, such reparations should be implemented in a manner that is gender and culturally sensitive and that does not exacerbate or even resolve any pre-existing discriminatory situation that denies equal opportunities to victims." End of quote, reference 9. In the same vein, the Appeals Chamber made this point in the Lubanga case, reference number 10. By way of an example, we would like to underscore that according to the evidence presented at trial, the Arab population represented the largest group in Timbuktu during the period in question in the judgment, reference 11. And as you can see on the screen, and this document should please be not shown to the public, approximately 32 of the individuals who were tried by the Islamic court were either of Arab or Tuareg origin. Whereas we note that only 4% of these groups are represented in the Sensemaker survey that was conducted by the fund. We should also underscore that there has been a change in the composition of the population of Timbuktu after 2012 because a significant portion of the Tuareg and Arab population fled in January and February 2013. Reference number 12. So, we therefore submit to the Chamber that it is essential to take into account all ethnic groups in Timbuktu and avoid focusing solely on victims of a single ethnic origin and their specific needs in terms of reparations in order to avoid creating marked differences between the different groups that make up the population of Timbuktu. This approach makes it possible to focus in on the needs of the community today, but also, as mentioned by my colleagues, also on the communities that existed in 2012, which are now located in other regions of Mali or even outside of the country. And this would enable us to address the systemic discrimination that exists in the Timbuktu community and provide redress for all communities. Now, thirdly, adopting certain presumptions would make it easier to promote broader access to reparations for more people. And the defense supports the adopting of these presumptions. In the Lubanga case, the Chamber established that it was not necessary to examine in detail the specific harm suffered, considering the obstacles that exist in the present case and the fact that it is a matter of redressing harm that is common to the community of Timbuktu. We are minded that of the opinion that presumption of economic, moral, psychological and physical harm are appropriate in this case. And it would be a way of not re-traumatizing those people after the harm that they suffered. Now, the fund, with its expertise and with the assistance of the LRVs and the registry, also have the necessary information with regard to those groups that are specifically vulnerable and their needs in order to put in place programs that are adapted to those groups and their vulnerabilities within Timbuktu. In addition, reference number 14 with regard to the adoption of eligibility for victims who demonstrate a sufficient connection to Timbuktu is also appropriate in the present situation, as it will allow for the inclusion of people who fled the city during this period and after 2012. Now, the advantages of this approach, which would be to provide remedy for these common harms and providing groups, more vulnerable groups within the community, would enable certain projects to be adopted that could take into account those harms that are gender-based. And we suggest two types of manner in which we can address this. So this is within we need first to address the specific needs of certain community groups within the framework of collective and community reparations, which will be adapted to this type of harm. In the Ahmadi case, for example, who was not convicted of sexual crimes, but the fund was able to establish a program that was tailored to the needs of vulnerable groups or the pre-existing vulnerabilities, namely women and girls within the community of Timbuktu. We would also support, as our colleague mentioned today, the inclusion of an intersectional approach that would respect a gender-based approach in the reparations order. A second manner in which we can remedy this harm would be to adopt a recommendation to the fund to use its assistance mandate, as occurred both in Lubanga and Katanga, even though these people were convicted of this type of crime, they could not be held financially liable. The fund has set up a number of programs under its assistance program. Now, with regard to the presumption of transgenerational harm, the defense is not opposed to the application of this, which comprises the reparations to I'm going to come now to my observations. I'm going to come to my conclusion. It is very important that the process be local and sustainable, based on a model that will meet current needs without compromising a long-term viable process. The community of Timbuktu has suffered from the withdrawal of MINUSMA and international NGOs. The security situation and political situation means that the community at this moment in time cannot depend on international organizations, but it has to depend on local processes coming from the population itself. So we understand that this hearing is an opportunity to provide our final observations. And the practice of reparations at the court has shown that this is a process that evolves according to the context and situation and is dynamic. The defense is ready to contribute creatively to the discussions. And this is the position that we have transmitted to our colleagues and are transmitting to the Chamber, namely that we want to find the solution that will be the most efficient and the most beneficial to the victims, whilst respecting the limits of the judgment against Mr. Al-Hassan. And thank you. That marks the end of the defense's submissions. Thank you very much.
Thank you to all the parties and participants for those submissions, which have been very helpful for the Chamber. The Chamber is now going to put some questions on matters that we consider require some additional clarification or more information. And I would ask all the parties and participants to please respond very focused on the question that has been posed, and to respond directly to that and not to enter into resubmissions, if I can put it that way. So we're going to begin those questions. I will turn to my colleagues first. Judge Flores, I understand you have some questions.
Yes, thank you very much, Judge Prost, and thank you also to all the parties and participants for their submissions today. I have some specific questions, and the first is addressed to the legal representative of victims. And in Mr. Zita, I think in your submission today, in the morning, 10:10, you stated that you advocate for the adoption of an order granting a symbolic amount to all eligible victims. And my question is, by eligible victims, you are referring to both direct and indirect victims for all crimes?
Madame la Présidente, Madame la
Madam President, Your Honours, with your leave, I will answer the question, hoping that the response will be satisfying and in response to your question. Our approach has always been a practical one, extremely practical, in identifying the eligible victims, those victims of persecution and those victims of other crimes, on the proviso, of course, of the eligibility of those victims. Now, on the basis of the symbolic reparations, yes, indeed, a symbolic amount of money that was pleaded this morning, we are saying that all eligible victims are indeed direct and indirect. We're talking here, these would be direct victims of persecution, and those direct victims would be those identified, which is the entire population of Timbuktu, with the restrictions that we have placed on that. The indirect victims, as we can assess them, the indirect victims of persecution are linked to those individuals who were not in Timbuktu at the time, but who might have suffered some harm associated with the harm of the direct victims. That is to say, those people were actually there during the period charged. So the harm, that would be the transgenerational harm, for one example. So to give you an easy answer to your question, yes, our proposal is aimed at the indirect and direct victims indeed. Thank you. Thank you very much for your answer.
Now I would like also to pose a question, and this is for the Trust Fund for Victims. And for the sake of the time, I will pose two questions. The first one is related to the security situation. And my question is, how does the security situation impact the Trust Fund ability to actually carry out a collective reparation program on the ground? This is the first question. The second, and I think it also has an implication, is about the principles. This morning you referred to the principles of reparations and also referred to their evolving nature and the importance of refinement. In particular, you mentioned two areas for refinement. One is conflict sensitive and the other is adaptive prioritization. Could you please elaborate a bit further on both elements, please?
Thank you, Your Honor. I will respond to the first question on the security situation first. As we are all aware, the implementation in the Al-Mahdi case is at the moment ongoing. So despite the security situation, reparation implementation continues until the end of this year, when the program will conclude. Each modality in our submission has a specific security profile. Each modality has different requirements. So we see it as the task of the Trust Fund in developing the implementation plan and later on in the implementation to actually assess and reassess the security situation with respect to each of the modalities according to the risk profile of each such modality. As has just been said also by the colleague in the defense, the reparation implementation is dynamic, and the security situation in particular speaks to that. We need to adapt continuously to any changes. We might have to pause a program. We we might, because of the security circumstances, but then we might be able again to continue. These decisions will have to be taken as they arise. From the perspective of the trust fund, also in this context, it's very important to point out the more we are connected to the community and to the victims, the more we have a good cooperation with the state, like for example Mali, a state party in the Al-Mahdi reparations, the better also the security situation is for us. The more we are grounded, the better the implementation will proceed. These are the submissions on the security situation. Just to conclude in that sense, we consider as the issues arise, we assess them, but from the very beginning we have a risk profile and we follow up on the risks that exist with respect to each modality. On your second question, the principles of reparations, indeed we have specifically averted to the conflict sensitivity as a principle that is at the moment, in our view, not yet mirrored in the reparations principles. There is a very clear principle on gender sensitivity, but the principle of conflict sensitivity, which is so important to, as we have heard from many of the colleagues today as well, to really move forward towards reconciliation and restoration of peace, if possible, in that environment is very essential. And as an example, in the Al-Mahdi reparation implementation in particular, we did not only have a consultant for gender sensitivity, but also for conflict sensitivity, which made it possible to create a participatory mechanism in a way that decreased the tension, that allowed for inclusion, and that really has embedded the reparations in the Timbuktu society. For the second point, the adaptive prioritization, this is linked to the submissions we made in June, the written submission, where you asked the question relevant to prioritization of victims. So in this respect, it's in the TFV's experience, determining the prioritization is best with the victims and the communities. For us today to determine the prioritization and say this is how it will be has shown in recent cases as difficult. Prioritization of measures or prioritization of victims does not always correspond to the realities of implementation in the end, to the security situation, to the funding available, to what we can actually do on the ground, and also to what is most accepted by the victims. So our suggestion, therefore, is to amend the principle that is already there on prioritization in the reparation principles and basically make it clear that the implementer, together with the victims and the community, will determine the criteria for prioritization, to leave, so to say, flexibility and to the trust fund and the program implementation in this respect. Thank you.
Thank you. Thank you very much for your responses. I have one last question. And for this question, I would kindly request a private session, Judge President. It will be very short, so I hope that we will remain in private session for a short period of time.
Thank you very much. Just for those in the public gallery, we will be going into private session where you will not be able to hear, but we don't expect it to be very long, so be patient with us. Court Officer, could we move to private session, please?
We are back in open session, Madam President.
Thank you very much. My thanks to Judge Flores. I understand that that was her questions. I turn now to my colleague, Judge Peck.
Thank you, Judge Prost, the presiding judge. And thank you for the parties and participants for your oral submissions. And I have several questions. And my first question goes to the legal representatives of victims in relation to the reparation to non-Muslim community. In your written submissions at paragraphs 81 and 82, the LRBs raised the need for the reparations to take the experience of non-Muslims into account. Can Council kindly explain what, in your view, would be the appropriate types and modalities of reparations to address the harm suffered by this non-Muslim community in connection with the crime of religious persecution?
Monsieur le juge, je vous
Your Honour, thank you for this question. You will have noted that this question on the reparations modalities which would be appropriate with regard to this category of victims was briefly addressed also by Maître Ncita this morning in his submissions, and we have indeed put this question to the communities which were met, to those responsible. We looked at places of worship of which were not Muslim, and what we have seen in terms of the harm, there's been the destruction of the buildings and their content, which are all the different religious objects therein. Everything was destroyed, and they were questioned with regards to what type of reparations there could be to repair this harm, and they said that having the religious objects back would be very difficult for a whole series of reasons, and therefore some kind of compensation would be something which, to a certain extent, could satisfy them or at least compensate a part of the harm suffered. But the fact of the complete destruction, both of the building and of the content therein, means that it's difficult to envisage in a concrete way in the field anything else than some type of financial compensation for those losses. I hope that I have answered your question. I just wanted to complete the answer from Maître Gilles Goffin. For the non-Muslim community, they have concerns where it concerns the religious places, and that is something that's been stated by Maître Goffin, and the sacred objects related to their religion. And the second part is where it concerns the physical persons. So there are moral persons and physical persons. Where it concerns physical persons, they say that they are part of the Timbuktu community, and as such, for the physical persons who are not Muslims, how can they be assimilated into the population of Timbuktu in general? Because where it concerns the religious objects or objects of worship, they are used by the religion, as was said by Maître Goffin. They ask for compensatory or compensation, and it could be collective, and they will arrange as a group to be able to meet their needs in this regard. Thank you very much.
Thank you. I especially appreciate your efforts to consult those affected and convey their views and concerns. My second question goes to the prosecution. And in your written paragraph 10 to 15, the prosecution provides different sources to determine the population of the city of Timbuktu. And in this respect, I wonder whether the prosecution can advance a theory as to the Timbuktu's population in 2012.
Thank you, Your Honour. Madam President, Diane Looping on behalf of the prosecution. Yes, in response to that question, Your Honour, whilst obviously we have to be clear that it's not possible to provide any exact numbers of inhabitants living in Timbuktu city in 2012, for the reasons we elaborate on at paragraph 13 of our written submissions, the prosecution does consider that the number provided by the legal representatives of victims of approximately 50,000 to be reasonable based on the different sources available and for the following reasons. As mentioned at paragraph 12, footnote 22 of our written submissions, the Malian Institut National de la Statistique states that there were 54,629 people living in Timbuktu urban commune based on the 2009 Malian census. It would then be reasonable, Your Honours, to interpret the other figure drawn from the Malian 2009 census of 87,552 living in Timbuktu urban, cited at paragraph 11 of our submissions, as rather being a reference to the total number of people living in all of the urban centres of Timbuktu region, rather than Timbuktu city alone. We would refer to the witness mentioned at paragraph 15 of our written submissions, who considered that this figure of 87,500 plus as being too high as a number of those living in the city. He believed that it was a figure closer to 35,000. Indeed, he lived in Timbuktu city during the events. We do consider him to be a credible and reliable witness. However, his figures are based on personal observations, and we would submit that numbers obtained from a more formal process of the Malian census to be more reliable, and that, therefore, the figures of 2009 provided of more than 50,000, as at 2009, to be likely to be reliable, and they will in fact be even lower than the figures one would have expected in 2012 if you take into account an increase, natural increase in population due to births. And even with taking into account unrest in the area at the time, for all these reasons, the prosecution considers the estimate of 50,000 provided by the legal representative for victims to be both not unreasonable and likely, in fact, to be a conservative figure. Thank you.
Thank you, the prosecution, for your further elaboration, explanation about your position, which was explained in the written submissions. Now, my next questions go to the Trust Fund for Victims. I have two questions, both of which are connected to the security situation. And I understand you have already mentioned and elaborated on some as the security situation's impact on your plan. And my first question is related to the draft implementation plan. Given the current situation in the country, can the TFV provide any estimate as to how many months you may need to submit a draft implementation plan? And the second question is are there any specific and particular types and modalities of reparations that are not feasible or recommended given the current security situation in the region? And conversely, are there any particular types and modalities that will be the most effective given the security situation? And your further explanation on this one will be helpful for the Chamber's better understanding.
Thank you so much, Your Honor. On the first question, that is the duration and the time needed to develop the draft implementation plan, and I note that you are linking that indeed to the security situation. I would like to recall that in the Ongwen case, we had the trust fund was given 6 months to develop the draft implementation plan based on a new format developed by the chamber. And in that period, the trust fund was able to have extensive consultations with the victims and then develop and many other stakeholders, and then develop the draft implementation plan. So to do so, therefore, the trust fund needs to collect and analyze diverse sets of data, needs planning, conduct these consultations, coordinate stakeholder inputs. The trust fund also has to assess the collected information, devise an implementation strategy, and then validate the proposed plan, including involving the board of directors and the parties. We seek, therefore, perhaps in the reparation order, if possible, clarification as to the format also of the draft implementation plan, and get guidance on how the draft implementation plan should be submitted. But given the security situation in Mali and the necessity for the trust fund to travel to Timbuktu and interact with the community and the victims, and the volatile security situation, the trust fund suggests that 9 months would be necessary to develop the draft implementation plan, should the format remain the same as it was developed by the trial chamber in the Ongwen case. The trust fund also emphasizes that the use of the 2025 Victims' Voices study, based on the collection of over 800 individual narratives, provides a robust foundation for engaging in meaningful discussions with the relevant categories of victims and affected communities. I now turn to the second question. The question turns around the feasibility or non-feasibility of particular types and modalities of reparations. The trust fund first records then that in its written submissions, certain types of and modalities of reparations were developed. In so doing, the trust fund has considered the appropriateness of these modalities of reparations. And part of such considerations of the appropriateness of reparation modalities are feasibility considerations. So the trust fund took these considerations into account in suggesting the modalities that were included in the submissions in June. In that sense, there is very little to add from the position of the trust fund as to whether or not the proposed modalities are feasible. Previously, I've already alluded to the fact that for each modality there will have to be a different risk profile, and feasibility, of course, is a matter that then plays a role throughout the implementation. That is the question I responded earlier. In that sense, there is one aspect that has been raised by the parties, that's in particular compensation, and the trust fund would like to underline that mobile money is a way how payments are regularly made in Mali, and it functions very well. Mobile money transfers have been used by the trust fund in the case Al-Mahdi, And that also ensured confidentiality in the sense that upon the evaluation of that case, victims were satisfied how the transfer of money took place, and they also felt safe. And I conclude the submissions on this point. Thank you.
Thank you. Back to you, Presiding Judge.
Thank you very much. Judge Peck indicates that's the end of his questions. I have just a couple of questions that I would like to pose at this point. First, Ms. Taylor, for the defense. The defense has made substantial submissions today about Mr. Al-Hassan's previous apologies, and in particular with reference to the apology, I think it dates from April 2025, the statement. You said in your submissions that this statement has been translated and distributed broadly. I'd like you to elaborate on that as to, in particular, the distribution point of view. How has it been distributed, if you're able to do so? And to where?
Certainly, Madam President. May I address this in private session, though?
You may, Ms. Taylor, I would ask you to be as brief as possible then once we go into private session. But I have asked for the elaboration myself, so. Court officer, and again, to the public gallery, we expect it to be a brief session. Court officer, private session, please.
We are back in open session, Madam President.
Thank you very much, Madam President. On your screens, you will see Mr. Alassane apology. It is public. It is specific. He has named his crimes, he has identified the victims, and he has apologized for their suffering. These are his words, his signature. In the same way that a judgment has weight, his written words have weight and are consequential. And the steps taken to disseminate this exceeds what has been recommended in other cases where the defendants were invited to give confidential apologies. And the UN Special Rapporteur on the Right to Truth, this is reference 11, has said that reparations should be tailored to the culture in question. And we have heard today that actions often speak louder than words. And I'd like you to focus on what Mr. Alassane is suggesting to do with his actions. He has offered to contribute money for an animal to be sacrificed and distributed as food, as is consistent with local traditions. He is also willing, which I did not mention earlier, to do a handwritten manuscript which can be handed over to the Timbuktu community and stored in a municipal building. In that way, if the victims wish to regard his apology, they can do so. If they don't wish to do so, they do not need to do so. The community can use it in whatever way they deem fit. We have also established contact with persons within the Vivre Ensemble Festival, which will take place in December this year. And that manuscript can be handed over to the Timbuktu community during the Vivre Ensemble community. We listened today to Maître Kasongo to discussing the possibility of written apologies to the groups of victims he represents. Mr. Alassane will write a written apology to those victims and any victim who wishes to receive such an apology. This is all that he is willing to do. His personal situation is dynamic. His family situation is dynamic. But while Timbuktu is his home, he's also given written assurances not to return to Timbuktu before at least March 2028 to respect the wishes of the victims. He does not know if he will step foot in Timbuktu again, but he does hope that through his conviction, through this hearing, through the actions he is committed to take, that the victims and the community of Timbuktu know what he did, know why it was wrong, and know that he apologizes to them from his heart. Thank you.
Ms. Taylor, on this same point, I'm going to turn to the legal representatives of victims in the Office of Public Counsel for Victims to ask if you have any comments, any additional submissions. You have made submissions on these issues, but anything additional arising from the submissions that have been made today, particularly by Ms. Taylor. I'll start with you and then proceed to the OPCV. Please, you have the floor.
Je vous remercie, Madame la Présidente.
Thank you very much, Your Honour. Just quite simply with regards to the issue of apologies, as you mentioned, we've already submitted observations in this regard, and our position is unchanged. The position of victims is unchanged, and just an additional remark in this regard is the possibly divisive nature of apologies when you have some victims are in conditions which are not totally controllable, I would say. And so there is a risk in all this that it could be done in that way. In something else I anticipate on the next question is with regards to apologies. At the moment, at this time, they represent an aspect where the victims, it's linked to the contribution of Mr. Hassan, and there's a lot to be said about that, but once again, perhaps I'm anticipating questions that you would like to put to us with regards to the issue of Mr. Al-Hassan's contribution and reparations. If there are no questions of the Chamber on that, I would ask you for the possibility to have go into that question as soon as possible, if it's part of the questions that you would like to put with regards to the position of the LRV and OPCV when it regards to the proposal of Mr. Al-Hassan for a contribution to reparations. Then we have a certain number of things that we believe are important to say with the objective of today's hearing. So I don't know if I'm anticipating future questions or if you would give me leave to address it now.
as well address it now because there's no plan-specific question on that, but if you have a reaction, which is obviously to what has been said today, please proceed, and then I'll turn to OPCV and you can address both points as well. And actually, while you're at it, there's one additional point which you may want to express a view on, which is whether you have any views on his willingness to contribute to future symbolic ceremonies. Whether you have any submissions on that. He's indicated that ability. So if you, but you can comment generally on contribution, including that if you wish or not. So please proceed, you have the floor.
Je vous remercie, Madame.
Thank you very much, Madam President. And I think that my answer on contributions goes to a certain extent into the position that we take with regard to a proposal in participating in symbolic reparations, because I would say that it's the same category of ideas and reflections that we would have to make. So quite simply, in 3 different points with regard to the proposals that have been formulated in terms of what is called a contribution, we have already said, and I think that my esteemed colleague has repeated it, that this is something which it's not easy to have a unanimous victim position on. Some victims are more in favour than others. Second point is that we insist on the fact that in reality it is important, perhaps today more than at any other time, to keep in mind that the convicted person is still responsible for reparations. He's responsible for reparations. The system was made as a system on which the convicted person keeps the responsibility to provide reparations, and the fund is an intermediary which can aid the implementation of reparations in the case of indigence of the convicted person. And as such, this system for us, and we have defended our case, that it's important for victims, it should be clear for everybody, the system should be that of monitoring, continuous monitoring the situation of the convicted person as far as possible, who has to assume his responsibilities when it comes to reparations, and if necessary reimburse the fund for reparations, even if obviously it appears as an idealistic scenario. In terms of the principle, it is important to stay with what was established by the statute and rules of procedure, and in particular Article 98. So we have also noted that there has indeed been discussions between the defence and the fund with regards to the way in which Mr. Al Hassan could contribute to reparations on the form or the type of contribution. And I think that at the end of the day, it's not about thanking Mr. Al Hassan for contribution to reparation, but for us, reparations are about his complete responsibility and the message that is given out here is really a bit concerning to have in the courtroom, because we have this idea of contributing to something which completely wipes away this notion of reparations, which I have to insist on. But once again, it is important. And with furthermore, as we have already heard from the defense, there are extremely detailed proposals as to how the reparations would be implemented. So it is quite an uncomfortable situation for us, because it would seem to me that the essential aspects are lost from sight, and the message has to be clear with regards to the issue of responsibility. And just one last point in order to finish. The system as set out in the Rome Statute, and which I've spoken about, in it, it is important as an objective to have non-repetition and dissuasion. That is to say that this idea that the responsibility remains with the convicted person, this is also important when you have a perspective of trying to dissuade repetition and to try to progress with regards to make progress with regards to the dissuasion objective. Well, I think that I'm going to stop there. Thank you very much, Madam President.
Thank you very much for those submissions, which are helpful to us. OPCV, please.
Merci, Madame
Thank you, Madam President. With regards to the issue of apologies, as I indicated in my submissions, or in some of my clients would not be opposed to Mr. Al-Hassan expressing his apologies. However, the question at hand is that I have a concern because I read, or I saw, and I know that while I wasn't in the trial, but I know that Mr. Al-Hassan has expressed apologies during the proceedings itself, and the chamber decided that it wasn't sufficient to accord a attenuating value thereto because it was too general. Now, because my colleagues from the defense have sent references to the expression of apologies more recently, well, I read this 3 times. I read this statement 3 times, and really, I haven't understood how this is different to the apologies which were made by Mr. Al-Hassan during the trial, because the note that the chamber admitted, or the comment of the chamber, was that the apologies was too general without an expression of remorse or compassion towards victims. So I'd ask once again with regards to this statement, I still haven't found in this, where is the remorse? Where is the compassion of Mr. Al-Hassan towards victims? In my perception, of course, it's a perception, a subjective perception, but when I see this text, in this statement, I see it as an attempt to justify himself by referring to the circumstances which were behind the fact that he had to commit certain acts. So, as a human being, I think when a person wants to give an apology, first of all, they have to recognize what they've done. But here, I never saw that Mr. Hassan said, indeed, I committed these crimes. However, what he says is that, indeed, I was convicted for certain crimes. And I think that is, or there is a difference there. Furthermore, Mr. Al-Hassan said here that, indeed, I condemn these practices against women, etc., etc. But where does Mr. Al-Hassan say, I apologize to all victims who suffered atrocious crimes, who suffered multidimensional harm, who continue to suffer from this harm to this day? Where is the compassion of Mr. Al-Hassan for or towards these victims? So by way of conclusion, I find that this statement can never be accepted by victims. That's one thing. Second thing, where it concerns the terminology, because we have had consultations, internal consultations, external consultations, and in fact, if I understand this, and please correct me if I'm wrong, within the framework of the cultural context in the Republic of Mali, apologies can mean that it could replace any other reparatory measure. And as such, I will give an example once again. I'm just representing a very limited number of people. For the people who accept, or the people who are not opposed to such an apology from Mr. Al-Hassan, that does not prevent them from saying to us, nevertheless, even with the apologies, we would like to have reparations for the harm suffered. So for these people, an apology does not replace the implementation of reparations to repair, as far as possible, the harm they've suffered. And for that reason, perhaps once again, I would, well, my position is this question is very sensitive, and once again, additional consultations with a wider group should be carried out in order to avoid a situation where there is tension within the community. Now, I've also listened to my colleague from the defense who said, well, we've had consultations with the chiefs, etc., with NGOs, yes, and I'm not giving any names because it was said during the private session, but where are the consultations with victims? Because I do understand that perhaps, but this is my perception, that if the chiefs are in agreement, then the community must be in agreement as well. It could go in that way because I've known that in other cases, but that does not mean that if the chiefs are in agreement, that the community has to be in agreement with it. So my suggestion is that additional consultations must be carried out with the wider group of victims to see what they think. It's not just about the opinion of the chiefs of the community. And now, furthermore, when it comes to the terminology here, perhaps, and once again, perhaps I've misunderstood this idea about apologies, that they could give rise to a certain erroneous perception. But what I would say is that rather calling that as an expression of remorse and compassion towards victims, rather than saying apologies, that's my suggestion. And another thing where it concerns a contribution or another form of contribution on the part of Mr. Al-Hassan, frankly, on the basis of my experience in other cases, for me, at the reparation stage, the only way through which the convicted person or the guilty person can contribute is financially. I really wanted to know more about that because I didn't see any other form of contribution that could be made, and ultimately I haven't found any. So for the victims, once again, consultations, I would suggest, because it's very important for the victims or the majority of victims in the population, that they accept it. And for myself, I say that on the basis of what we have had as a result of the consultations, and that is that for victims, if Mr. Al-Hassan indeed does want to contribute, then this contribution must be significant. That is to say that the victims don't need a symbolic contribution because they have suffered extreme harm. They continue to suffer from extreme harm. They do not need a symbolic contribution, and above all, not a financial symbolic contribution. And I'm just going to finish it, but we've heard about the Trust Fund for Victims. Even if, according to the most conservative estimates, it's going to cost a lot of money, and we understand that Mr. Al-Hassan can't contribute in a significant way. So for the victims, no, I think that it would be perhaps considered as insulting. It could be considered as insulting. Thank you.
Thank you very much for those submissions. I have one final question, and it is directed to OPCV. Very brief answer, please, to the question, if you could, because it's just very focused on an evidentiary point. This relates to a completely different topic. It is, the Chamber notes that in some of the cases of sentencing without due process, so it focuses on that, there is no direct evidence in the court record that the sentences were ever carried out. And in your submissions at paragraph 44, you're seeking both moral and physical harm should be included in reference to the direct victims of the crime under count 6. Just briefly, can you elaborate on your proposal, notably in the circumstances outlined above? What are you arguing specifically in terms of the basis for, in particular, physical harm?
Thank you, Madam President. I'm going to try and be very brief. I do apologize that I was a little bit lengthy. I would remind you that in the judgment, the crime under count 6 was committed in two manners, either by the execution of a sentence in the absence of a judgment where the sentence was carried out immediately in the sense that the victims suffered immediate harm, or a sentence was handed down by an irregularly constituted court and the victims were placed in detention. And in the context of that detention, they suffered various forms of harm. I understand that certain aspects of the detention were not part of the judgment, but as the standard of proof is a little bit different, and with the effort that we have made and in the submissions that we have made in the filings, I can explain. And I would like to draw the attention of the Chamber to the fact that according to the jurisprudence of the court in the Ongwin case, and this is the Reparations Order, paragraph 168, the physical harm can be one of physical suffering that is not caused by a physical wound. I think that would be something that could be in support of our approach, and I thank you.
Thank you very much for that clarification. À moins que mes collègues n'aient
Unless my colleagues have any other further questions to put, the hearing is coming to an end.
Thank you very much, Madam President. And I would ask to just have 1 or 2 minutes to have the last word, as is the right of the defence, to address issues that weren't raised previously. As I said, it'll be very brief.
colleagues.
It's on an issue that touches Mr. Alassane responsibility personally.
Ms. Taylor, we're not in the trial proceedings, we're not in the sentencing proceedings, we're in the reparations proceedings. You've had an extensive opportunity to address the matters, you've made extensive submissions. The responses I've drawn from the victims were directly related to matters that you raised, and this can't be a ping-pong match, so.
We completely understand. It was just on the issue of the count 6, the additional harms of count 6. That was the only issue we were intending to address. And as I said, I could address it in 1 minute. I didn't address it earlier because we were waiting to hear what the submissions were.
Well, I think we have sufficient information on this. There's submissions on count 6. We have your submissions on count 6. So that was just a point of clarification in the OPCV. So I really don't think we'll need the submissions. We're well familiar with the count 6 arguments. I just wanted some clarification on the physical harm point. So I think we can conclude it there. Thank you very much. L'audience touche à sa fin.
The hearing is coming to a close, and before we conclude this session, I would like to thank the parties and the participants for their spirit of cooperation and for the good manner in which the discussions unfolded today. I would also like to thank the interpreters. It was a little bit difficult today. Thank you for that. The court reporters, and well as the security guards of the court, for their essential contribution to the good conduct of this hearing. I'd like, finally, to address my final words to those who took part in this hearing from the gallery, public or further afield online, and I hope from Mali, with a particular thought for the victims and the entirety of the Timbuktu community.
The Chamber will now proceed to the deliberation phase of these proceedings. The parties, participants, and the public will be informed at the appropriate moment of the date the reparation order will be rendered. And as there is nothing further, this hearing is now adjourned.
All rise, will you lever?